Good evening, ladies and gentlemen. I'm Johannes Chen of the Faculty of Law. And first of all, let me welcome everyone for joining us tonight. Tonight is the first of a series of 3 lectures on public law. And I'm particularly pleased, and it's my great privilege to introduce our speakers for this series of lectures, Mr. Richard Clayton, Queen's Counsel. And Richard is a well-known barrister in UK, specializing in this field. And he is best known for being one of the authors of Clayton and Tomlinson, The Law of Human Rights. For those who practice in this area know that this is a book that we frequently refer to in our courts, as well as many courts in the common law jurisdictions. And apart from being a barrister, Richard has also served as a recorder and a deputy high court judge, and he has also practiced in various jurisdictions outside UK, and Richard told me that one of his favorite jobs is actually serving as the UK representative on the Vienna Commissions under the European Council of Europe. And in that capacity, he has advised the constitutional development of various jurisdictions. I understand this is your second time to Hong Kong, although last time he didn't have much chance to see. I'm not sure whether he has much time to see Hong Kong this time. We asked him to give 3 lectures, and this is the first one. So let's just welcome Richard for this series of lecture. Thank you.
Thank you very much. It's a great privilege to be able to speak to you on a subject which is really central to Hong Kong's democracy and governance. Hong Kong has a long and distinguished legal tradition of analyzing the scope and limitations of constitutional rights. You've, of course, begun that process with probably before, but with the Bill of Rights Ordinance, which was 10 years before British lawyers turned their minds to these questions, at least properly, until the Human Rights Act. Before then, we were beginning to develop a common law of human rights, which is rather complicated and is not the subject that I propose to talk about, but I'm happy to deal with that in questions if people would like. I propose during the course of this week to talk about contemporary themes in public law, looking at the recent developments in Hong Kong courts in 3 areas. Right to freedom of expression this evening, tomorrow the equality rights essentially, and on Thursday the right to property. I propose to look at those developments by making comparisons where relevant with developments in other human rights jurisdictions. And this evening we'll specifically consider freedom of expression in the context of judicial review, its impact on practice and procedure, and its impact on private law litigation. The final Court of Appeal in the Haisan development case reaffirmed the generous approach the Hong Kong courts have always taken to human rights decisions from other jurisdictions, drawing heavily on the jurisprudence of the European Court of Human Rights, the United Kingdom's case law on the Human Rights Act, and, for example, also the decisions of the Canadian Supreme Court under the Canadian Charter of Rights and Freedoms. I believe myself that there is great value when undertaking human rights work by examining the case law of different jurisdictions. It seems to me that so many human rights questions are universal in nature, and it's often illuminating to draw upon the collective wisdom emerging from different constitutional approaches to the same issue. And that, I think, is a common pattern in most courts which address constitutional issues or human rights. It's perhaps most marked in the South African Constitution, where the South African Constitution Act specifically requires the Constitutional Court to interpret human rights in line with international law. At the same time, when a court is applying comparative legal principles, it must always be astute to recognize the importance of different legal, political, and cultural traditions, as well, if appropriate, to giving effect to the particular language used in the specific rights instrument. For the purpose of this series, I'm going to look at cases where relevant from the United Kingdom, Strasbourg, the Privy Council, the United States, Canada, South Africa, Trinidad, and elsewhere. I have found the exercise of analyzing Hong Kong constitutional rights for the purpose of these lectures from a comparative perspective really very fruitful. It's always fascinating to discover how issues emerge in different jurisdictions and to learn from the insights that provides. Before I look at a few cases, I would like to mention two things. First, I'd like to particularly thank Johannes Chen, who has really provided assistance to me in every conceivable respect in trying to get these themes developed. And secondly, can I apologize in advance for my inability, I suspect, to speak Chinese appropriately, so I hope you'll forgive me when I make a mess of case names. Now, this evening I propose to focus on freedom of expression, and of course you will all know that under the basic law that protects freedom of expression, and it's not an absolute right, it's subject to the by provision by law, and it has to be necessary, which means proportionate. In my last lecture, I was looking at some length at the Haisan development case, because it does seem to me that that is a case which bears scrutiny. However, dealing with freedom of expression, first of all, it's worth reminding oneself of some high level of judicial comment about the character and significance of freedom of expression, which it seems to me is fundamental to any kind of notion of a constitutional democracy. In the ex parte Sims case, the case which went to the House of Lords about the prisoner's right to have access to the press in order to protest that he was the victim of a miscarriage of justice, Lord Steyn, now sadly retired some years ago, reminds us that freedom of expression is intrinsically important. It is valued for its own sake, but it is also instrumentally important. It serves a number of objectives. It promotes self-fulfillment in individuals. Secondly, in the famous words of Mr. Justice Holmes, echoing John Stuart Mill, the best test of truth is the power of the thought to get itself accepted in the competition of the market, from Abrams in the United States. Thirdly, says Lord Steyn, freedom of speech is the lifeblood of democracy. The free flow of information and ideas informs political debate. It is a safety valve. People are more ready to accept decisions that go against them if they can, in principle, seek to influence them. It acts as a brake on the abuse of power by public officials, and it facilitates the exposure of errors in the governance and administration of justice. And those views of Lord Steyn were accepted as a general proposition by Chief Justice Ma in the Kwok case. Freedom of expression is closely allied to other rights, such as the right of freedom of a peaceful assembly, which is a subject which seems to have cropped up some importance in recent times. I'm only going to look at some of the cases, I'm afraid, but no doubt people will have strong views on many of those issues. The Hong Kong courts have regularly stressed that freedom of speech and peaceful assembly and demonstration are all fundamental rights. As the final court of appeal put it in the Kwok case, these freedoms are of cardinal importance for the stability and progress of society, conflicts of resolution and tensions through open dialogue, enabling dialogue and debate to take place. They enable citizens to voice criticisms, air grievances, and seek redress. And minority views may be disagreeable, unpopular, distasteful, even offensive, but the tolerance is a hallmark of a pluralist society. That is actually a Strasbourg formulation, which I shall return to. But before I look at the way the cases have developed, I think it is really worth underlining how central freedom of expression is in the political and constitutional world which we like to think we live in. Now, the first topic I'm going to look at is freedom to demonstrate. And of the three cases I want to look at, This first one is perhaps the least exciting. It's the Chi Mai Ming case, where the Court of Appeal considered the constitutionality of a statutory scheme regulating the display and affixing of bills and posters, and various constitutional issues were engaged. I can take it really very quickly because I don't think it is hugely exciting. The case turned into being a permission or leave hearing, and basically the Court of Appeal granted permission on the basis of a prescribed by law question, which is a topic I'll be looking at from time to time during the course of these 3 lectures, where it seems to me that the Hong Kong courts may be unduly generous to the scope that they give the government or the state. And they also, in this case, the Court of Appeal granted leave on a new proportionality ground, which is significant in terms of, it basically set the proportionality test in the statutory context. So there was a rather broad brush first to go, and then the argument was refined. The case which I find particularly interesting, and where I think, if I may say so, the Hong Kong courts are radically out of step with international human rights jurisprudence, is really dealing with this question: whether rights are engaged when undertaking activity which is unlawful. And the Hong Kong courts appear, at least in a couple of cases, to have taken a position on that, and for reasons which I will develop shortly, I think that that approach is open to question. The case that really generated the thinking for me on this is a case called Lyman Locke, which was dealing with the question of whether the right of freedom of expression of an assembly entitled an individual to demonstrate at whatever locality the protesters chose. The approach adopted by Mr. Justice Chow appears to be inconsistent with the Kwok case, and out of line with the jurisprudence of the United Kingdom courts under the Human Rights Act and of Strasbourg too. Mr. Justice Chow held that the applicant's right to freedom of expression, assembly and demonstration were not engaged because those rights did not entail an ability to choose the forum, i.e. the place, where you want to demonstrate. In Lyman Locke, the applicant chose to demonstrate in a viewing area at a flag-waving ceremony where he was not entitled to be. So the question that arose, or so it was put, was does he have any rights at all in a setting where he has no legal basis for being placed where he was? In the course of his judgment, the judge looked at an earlier decision of Mr. Justice Chung, as he then was, in a case called Kwok, where he held that the right of freedom of assembly stopped at the boundary of a private residential property belonging to others in the absence of any permission to enter. So essentially, the issue is it lawful, are constitutional rights engaged if it's unlawful to be in the place in question? Now, in fact, slightly oddly, as it seems to me, Mr. Justice Lam, in the case that was one of the cases which was reviewed, looked at some British jurisprudence under the Human Rights Act, in particular a couple of decisions of Lord Neuberger, who I understand graced this place very short while ago, and particularly 2 demonstration cases. One, the Occupy movement, which stayed outside St. Paul's Cathedral for a very long time. And the gist of it was that Lord Neuberger said, and I'm going to develop this point more, is that basically the right to demonstrate is a right to demonstrate whether you're there lawfully or not. The right's certainly engaged. The fact that it's an unlawful place is obviously a relevant consideration when proportionality is considered, but it can't, as it seems to me, be determinative. But irrespective of whether it could or it might be determinative. The one thing answer you don't get to, it seems to me, is the idea that occupying or being in an unlawful place negatives any ability to rely on a right. I mean, that position is very well established in Strasbourg. I mean, for example, in a case called Buckley, completely different context, a gypsy case about the right of respect for home, the British government in Buckley tried to argue that because the gypsies weren't lawfully there, they couldn't rely on a Strasbourg right of respect for private life, the family, and the home. And that was just rejected entirely by the Strasbourg court. Johannes was kind enough to mention my involvement with a body called the Venice Commission. I'll explain a little bit about it because I want to talk about an opinion we gave, which I think graphically illustrates why the Hong Kong courts, in my view, have taken a wrong turn, if this is really the position that rights aren't engaged by virtue of unlawfulness. The Venice Commission is a body set up under the Council of Europe, so it's not the EU, although most people seem to think it is. Of course, as you know, in England with Great Britain, we seem to be thinking we're going to leave that anyways. But leaving that to one side, the Council of Europe's most significant institution is the Court of Human Rights in Strasbourg. But one of the bodies it set up with the fall of the Berlin Wall in 1989 was the Commission of Democracy Through Law, better known as the Venice Commission, because it meets four times a year in Venice. And what that body does, indeed it was set up because of the fall of the Berlin Wall, was to try and come up with some sort of systematic way of looking at constitutional rights in a more organized approach than relying simply on random applications to the Strasbourg court. The reason why I'm taking rather a long run at this is in 2012, before President Putin ran for election, there were some concerns in the Council of Europe about developments in Russia, which, if you go there, not that very surprising, really. And I was one of a group of 3 people who had to report on freedom to assemble. And the Russian legislation on this rather graphically illustrates my point. In Russia, if you want to demonstrate, you have to seek permission from the authorities to demonstrate. And if the authorities provide what is called in the legislation a well-motivated proposal to modify it, then you have to, the prospective demonstrator has to accept that proposition. If they fail to, they're acting unlawfully. Now, what the Russian state was doing was moving demonstrations out of Red Square and putting them in the suburbs so no one noticed them. Now, the Venice Commission on that occasion took the view, and I certainly strongly argued for this as one of the 3 reporters, that was no right to demonstrate at all. It was a permission, not a right. But the bigger point I want to make is that when you're dealing with certainly in international human rights jurisprudence, it's axiomatic that you can't use domestic law to define the scope of human rights or constitutional rights, because the whole point of human rights or constitutional rights is they're supposed to provide a sort of meta-legal system or a system that trumps. I'm not saying that breaking the law is proportionate in every situation. That is not the radical proposition for which I'm contending. But if you think about it, if you have a comparative system of law like the human rights system, whether it's in Strasbourg, Inter-American Court of Rights, Asia, or wherever, if you allow domestic laws to define the scope of rights, then they evaporate, because however you change the domestic law can, in principle, limit the scope for it to take effect. So I've made said rather a lot about that, because it seems to me, of all the cases I've read, and I've read quite a number now, for the purpose of preparing this lecture, this particular approach strikes me as really significantly out of step with everywhere else. And one can't help feeling, and I'll be coming to some other cases shortly, that this idea that badges of lawfulness, negative constitutional rights, may well resurface as an argument that gets developed further over the next couple of years. A slightly more mundane example of the right to demonstrate was a case called Chi Lun Public Bus, which is about the Occupy Central campaigns, and essentially was an application about the constitutional right to demonstrate against the context of a claim brought based on public nuisance, so a tortious claim. And the essence of it really is that the Court of Mr. Justice Poon relied, as he must do, on a Court of Final Appeal case called Yong Mei Wan, where essentially the Court of Final Appeal reduced the issue to one of reasonableness and to express the view, which is entirely understandable in principle, that a person who creates an obstruction cannot be said to be acting without lawful excuse if it's a reasonable user of the highway, and therefore whether a particular instance of obstruction goes beyond what's reasonable is the critical issue. It's a question of fact and degree. And this point was emphasized by Mr. Justice Poon. He was talking about the scope to demonstrate in terms of public nuisance by referring to a peaceful demonstration. So inevitably, if a demonstration is not peaceful, it's going to be taken outside the scope of a defense to a public nuisance claim altogether. So according to the approach, which is, I have to say, common, it's not exclusive to Hong Kong. There's a case in the House of Lords, one of the very few cases where the Labour Chancellor, Lord Irvin, ever sat in a judicial capacity, where again the benchmark test is really reasonableness. Now, I'm now going to look at a couple of cases on elections. Again, I think the second case is rather more interesting than the first. The first case is a case called Wong Chi Feng, a well-known and controversial figure, then aged 19, wanted to invoke the right to become legislators at the age of 18. And its principal interest, up to a point, I have to say, is that Mr. Justice Old rejected the contention that it was for the respondent to demonstrate that the restriction was proportionate. That isn't a hugely surprising conclusion. If a case doesn't reach the relevant threshold of arguability on the claimant's own case or applicant's own case, then why do you really need to look at it doesn't get better, it gets worse once you look at the other side's case. Anyways, what was interesting, and this seems to be a common theme in the Hong Kong courts, is that in the context that they were dealing with, reference was made to a further decision called Kwok Ching King. I've murdered that. Anyways, I do apologize. Where the Chief Justice Chang emphasized that when applying the proportionality test, a broad margin of appreciation should be given to the government or legislature regarding its discretionary judgment on issues relating to political judgment. And that's a common theme. And I'm going to address that in relation to a case which I have to say I find really less than compelling, a case called Kwok Chen King, which was a decision of the Court of Final Appeal dealing with the right of legislatures to create by-elections. And I'm sure it's a very well-known case here. It's obviously very controversial. And again, what's striking about it is that the court took the view that it was a political judgment that there was a broad margin of appreciation. Margin of appreciation is never a phrase one should really use in the context of domestic law. The margin of appreciation, which is itself a slightly slippery and elusive concept, is actually a concept that international courts apply when looking at the extent to which the domestic court is the prime decision maker. Margin of appreciation isn't really quite the right word. David Panic, who many of you will have come across, wrote an article in 1999 calling it the discretionary area of judgment, which simply arrives at the same result by a different name. At any rate, what's slightly odd about this case, as it seems to me, is that the Court of Final Appeal decided that the test of review was a somewhat generous one of whether it's manifestly without reasonable foundation, a test that I will speak about more in my last lecture as a matter of principle, but I won't be giving much away by saying I think that is a test which is a long distance from what people call a structured proportionality test. But to get back to the context, because I do think this is a really quite extraordinary case, as I understand it, there was a long and controversial and intense debate about a bar on by-elections, and all this arose because it was designed to deal with the perceived mischief that you would undermining the electoral system by legislatures resigning in order to cause a by-election in which they would stand. And the Court of Final Appeal seemed to take the view that this was a relatively minor encroachment. And indeed, the government, in some of the submissions made and the evidence before the court, referred to this stratagem, devised as a political stratagem, as an abuse to someone to deliberately create, to resign in order to cause a by-election. For what it's worth, that's a really odd thing for a British person to hear, because one can think of two people. The current Minister for Exiting the European Union, David Davis, resigned in 2006. Very odd reasons. He resigned actually because he was concerned about the way in which the Blair government, the Blair Labour government, imperiled civil liberties because of the detention without trial period and a really important human rights case called the Belmarsh case. Anyway, he resigned because he had lost the leadership election. I think he's a bit fed up generally, but he thought he'd do that. And then, of course, Zach Goldsmith, who is a rather odd guy too, he resigned in protest at the government's proposal to build a third runway at Heathrow Airport recently, stood as an independent, and then the Conservative Party grabbed him back and just narrowly kept that seat in the rather disastrous general election of earlier this year. But even that is a really good example of something which I think is a principle which calls into question the whole of the Final Court of Appeal's approach. Because earlier this year, the British Prime Minister called an early general election, she said, to consolidate her position about the Brexit negotiations. And in doing that, she overrode the recently enacted Fixed-Term Parliament Act, which was quite a significant constitutional development in the United Kingdom, since we don't really have much written constitutional rules anyways. Of course, the outcome of the general election was not entirely congenial to Prime Minister May, but leave that to one side for the moment. What I think is odd is in the United Kingdom, and I think this is more general really, is that politicians who make political gestures, even to the point of creating by-elections, are making political gestures. And I find it really very odd that that the Court of Final Appeal took the position that it did. It's also of interest, I've already mentioned the Venice Commission, but the Venice Commission recently did a report on the exclusion of offenders from Parliament, which was a comparative study of quite a number of different countries. And it arose because of a problem in Albania, where there was the opposition party agreed to end a boycott. And there were about a third of the Council of Europe countries, which is 47 in all, have detailed constitutional provisions concerning parliamentary candidates that place various restrictions that prevent convicted persons from running for elections. And then more recently, in fact, at the Venice Commission meeting I attended 3 weeks ago, 2 weeks ago, 10 days ago, we approved in an amicus brief to the Strasbourg court in a case brought by no less a human rights luminary than the former Prime Minister of Italy, Mr. Berlusconi, who is complaining about his expulsion from the Italian system. And he's brought a case in Strasbourg. But the really interesting point about the Venice Commission material is what it identifies is that criminal behavior is a reason for people obviously not being regarded as being fit to stand in Parliament. Now, of course, you can criminalize anything, so it's not a complete answer to say that something that's a crime must prevail as this sort of governing rule. But what I do find slightly odd, if I may say so, about the decision which I'm struck by is that essentially this was a politically motivated tactic. And if you were to look at sort of general principles of freedom of expression, if that's the issue, generally political content is the highest priority that we give human rights. So to me, it's slightly odd. It's also slightly odd because there were cases that weren't mentioned, which I find rather strange. The case of Sauvé, which is the Canadian case on prisoner voting rights, there are two of them actually, was mentioned, but the Court of Final Appeal wasn't much taken with that. But no reference was made to the Hearst case, which is a very strong indication by the Grand Chamber about the central role of electoral rights in a constitutional democracy. And that isn't discussed at all. And it's worth saying that not only not only has Hearst been law in Strasbourg, not of course in the United Kingdom, I'm afraid to say, because we've refused to accept the decision now made 12 years ago adverse to the British position. But that view of the sanctity and centrality of the right to the stand of election was reaffirmed in a second Grand Chamber case called Scoppola in Italy number 3, when the British government specifically argued Strasbourg got it all wrong, and then again in front of the Supreme Court in a case called Chester, where again the British government argued that Strasbourg got it all wrong. And what I did find equally odd is that the cases which the Court of Final Appeal looked at seem to me to be really have no obvious relevance at all. I mean, there's a case called Lord Carlisle, which is a remarkable case, frankly, where an Iranian politician was invited to speak to the British parliamentarians, and the government said, no, can do, you can't come in. Why, said everyone. Well, because it's inimical to international relations. And it's a controversial decision. And it is certainly an outstanding example of deference by the British courts in a proportionality context. But what it has to do with the issue before the Final Court of Appeal, beyond demonstrating that there are cases which show deference, strikes me as difficult to understand. There is, although I don't think it's a particularly striking case, a case of the South African Constitutional Court which held that the prohibition on legislators crossing the floor is not an essential component of a multi-party democracy. So that was thought to be okay, and that seemed at least a little closer to the stratagem that the political campaign, which was having by-elections, was about. Well, that also has struck me as a case of huge interest, and where I mean, I don't think any human rights case has self-evident answers, but that one is perhaps less self-evident than some others. Television licensing, that has been a subject of litigation here as well. The Hong Kong television network got involved when there was as probably some of you or most of you will know, you once only had 2 television operators, now you're blessed with having loads of them. And there was the government basically set up a tender exercise. The facts are quite complicated. The Court of Appeal basically reversed the trial judge on everything, really. But one of the things about the case, well, I suppose there are 2 broad issues in the case which are slightly odd. One is the position that was taken about prescribed by law, where there was foreseeability. There are 3 limbs, you know, is it accessible, is it foreseeable, and does it exist? And that a rather nuanced view was expressed by the Chief Justice Chen to the effect that it's a context-based question, which strikes me as being entirely sensible. But what was also odd in the case was there was a proportionality argument. And although the Chief Justice looked at a House of Lords case called Belfast City Council, he seemed to be troubled by the whole thing. What had happened in the issue which troubled the court in the case I'm talking about is what stage do you apply the proportionality test? Is it the question of whether the tender should be done at all, or is it when a particular decision's made? Is the particular decision made pursuant to the exercise in question? Is that proportionate or not? And he seemed to query whether it was appropriate to challenge the application of a principle to the specific set of circumstances, although he decided the case against the claimant both ways. But that's a slightly unusual, as it seems to me. The next case, because I'm conscious of time, and I'm very happy to take questions at the end if everyone is still feels awake. Just talk briefly about interim relief and freedom of expression, a case brought by the Hong Kong Journalists Association, which was about the government's rejection of online media participating in covering the chief executive's election to be held in March of this year. And there had been complaints over time about the way the government had treated this. The principles were not in dispute. It's basically, is there a serious issue to be tried? Adequacy of damage, balance of convenience, the standard American cyanamide sort of test. The wrinkle to it all, really, was that it was, in effect, a mandatory injunction sought late, and as certainly I can have first-hand experience of as well, you leave things too late, sometimes it doesn't work out so well. So that's really all I want to say about that. I'm more interested in a case which, as I understand it, has yet to be argued before the Court of Final Appeal, the Kwok Chen case, which again strikes me as open to question. 3 defendants stand trial. They're jointly charged with contravening an administrative instruction of the Legislative Council and obstructing an officer in the execution of his duty. Their appeal was dismissed. The Court of Final Appeal has given permission. The administrative instruction in question states, "No person shall in a press or public gallery display any sign, message, or banner," which is exactly what they did in the Legislative Council. And essentially, one of the defendants wore a T-shirt with an offensive phrase on it, and also had a swastika. They also, one of the police officers tried to pull a message off by someone in respect of a second person, And that basically resulted in, a melee, I think overstates it, but an incident which had some physical sequela, and indeed the person who was pulled had suffered some injuries. And then there was a failure about behaving in an orderly manner, where apparently the whole scene became rather rowdy and noisy, and against all of those backgrounds. So we're not talking about top-end bad behavior, if I could put it like that, but we are talking about behavior in the context of essentially the Legislative Council. And Mr. Justice Wong decided, and none of this is particularly controversial, that freedom of expression and speech are qualified. The question of whether what premises you're in is obviously a material factor, and he accepted that the Legislative Council has the power to govern its own affairs, and he held that the public do not have a right to demonstrate in a Legislative Council building when meetings are in session, and he made other adverse findings to the claimants' appellants about the signage and so forth, and concluded that to allow persons holding different positions or views to create a scene where there's mutual display and not safety or order is a view divorced from reality. If I may say so, that is a very striking approach when you look at the conventional case law on freedom of expression. It may be inconsistent with the flag desecration case, which takes here the Jingkang-Siu, if you can call it like that, which calls for a generous interpretation and reminds us that freedom to express ideas which are disagreeable is inherent to freedom of expression. That is a constant theme. It's been repeated to Strasbourg. The sort of standard litany of principles that Strasbourg often sort of states and restates is that freedom of expression applies not only to information or ideas that are favorably received, but also to those that offend, shock, or disturb. These are the demands of pluralism, tolerance, and broad-mindedness, without which there is no democratic society. And Lord Justice Sedley, when he was sitting at first instance, reminded us then, in a case called Redmond Bates, freedom of speech includes not only the offensive, but the irritating, the contentious, the etc., and so on. And there is an interesting Strasbourg case, if you find this kind of thing interesting, called Eon and France, which held it was a disproportionate interference with freedom of expression to prosecute for insulting the French president by a placard lampooning him with a phrase, "Get lost, you sad," expletive deleted. So that was thought to be non-criminal. It also strikes me as if the actual issue in this case is really very narrow. And I can't help being reminded of the approach associated with Mr. Justice Black in the American Supreme Court, that's now some years ago. I believe, he says, this is a case from Ginsburg, but this expresses his view, that federal government is without power under the Constitution to put any burden on speech or expression of any kind as opposed to conduct. And that's a distinction which I think is really quite important to remind ourselves of. There is a difference between, and it's central to American freedom of expression jurisprudence, but there is a big difference between sort of passive demonstration on the one hand and, a melee. And it does strike me as if it's an issue which is ripe for some more careful views in the Court of Final Appeal. What will happen, of course, I have no idea. Skipping through, there was a series of cases involving this university which concerned an interim application to remove all audio recordings of a confidential meeting of the University Council. Somewhat surprisingly, it seems to me, the plaintiffs seemed to say, well, we should apply the Human Rights Act, to which the court's short answer was, well, it's not the law, which is fair enough. When the Human Rights Act was drafted, there were certain provisions in it which were designed to create hierarchies, and one of them was basically to protect freedom of expression on interlocutory, interim basis. But that, as it was said to be really not key. It's not part of Hong Kong law, and there was no reason why Mr. Justice Lam felt he had to rewrite the law. Well, one entirely understands that. And then there's the breach of confidence case, which was the final hearing of that case. Although it wasn't defended, the case is useful. This is the University of Hong Kong and the Hong Kong Commercial Broadcasting, because Mr. Justice Lam set out some basic principles about disclosure and so on, which I think are pretty uncontentious. And then the last case I'm going to talk about very briefly, I think, is the Boa International Case, which is about the interplay of freedom of expression rights with defamation. And certainly in the United Kingdom, Article 10 has had an important impact on the way in which the defense, particularly of newspapers and so forth, has become more generous and broadened in consequence of the Human Rights Act. And in this case, it was a really rather a complicated case. But you'll remember, or you may remember, that in a case called Chen and C.Y. Chan, Lord Nichols decided that the fair comment defense could only be lost if a defendant knew his comments were untrue and reckless. The Boa case was a libel and malicious prosecution case, immensely complicated, essentially about an article published in Next magazine about the presence of a chemical known apparently as 1.4 dioxane, which was in shampoos. It covered many technical issues, lasted 39 days, a lot of expert evidence, and essentially the case boiled down to the judge couldn't make a finding on a key issue. The technical evidence showed that the dioxin was a confirmed animal carcinogen and a possible human carcinogen, but the actual effect of it on humans was unknown. So there was a lack of empirical data. So the case actually turned on who bore the burden of proof, which is unusual, especially after 39 days of evidence. Rather irritating, I should have thought, for the judge. Anyways, there was a bit of an argument between the parties as to what was involved, and the claimant tried to argue that because the article involves a matter of public interest, the burden lay on the defendant to prove the impossible, which oddly enough the judge wasn't particularly taken with, and he rejected it. But also what is slightly odd is he distinguished between a defense of justification on the one hand and a public interest defense, which is the classic kind of Sullivan and New York Times based defense, which has been developed in many jurisdictions to allow newspapers to essentially express views which may not be as thoroughly researched as they could be, but nevertheless are not inimical to the public interest. So to try and pull some threads together, if I may, having had the opportunity to survey Hong Kong case law on freedom of expression, it's quite apparent that the courts have developed a principled, rigorous, and sophisticated approach to how that constitutional right to freedom should be expressed. But there do seem to me to be at least a number of decisions which are open to question. For my part, and not everyone will agree, the Kwok Chen case strikes me as a striking conclusion when there are a number of powerful countervailing arguments that cut the other way. And the other case, which really I was struck with, is the principle, if it is one, that domestic legislation can define the limits of rights in Lyman Locke. if that were adopted more generally, or if indeed is the law, that would mean that Hong Kong constitutional jurisprudence would develop in a direction which is significantly out of step with conventional standards of international human rights courts and of international human rights instruments. Well, that's all I propose to say. I hope you found that interesting. If anyone has any questions, please.
Right. Thank you, Richard. You have covered a very broad range of cases within the last 50 minutes. I think it took me almost a whole semester to teach this range of cases. I'm sure that there will be a lot of questions from the audience. If I just make just two general remarks. One is you refer to the absence of reference to the Hearst case in the by-election case. Yeah. And indeed, in a subsequent case, in a case involving the disqualification of some legislator, I did refer to that case, except that it didn't make any change to the, make no difference to the outcome. And the other point I made, you refer to the Journalists Association case, and you make a remark that things were left to too late a stage. I happen to be counsel in that case, and indeed part of the reason for the delay is the government dragged on for almost 6 months there. But then that case raised an interesting issue, which is touched on in your various part of your papers, is when it comes to interim relief, particularly interim injunction, we have seen that in Occupy Central, we've seen that in university, is the American cyanide test, the balance of convenience, is it too low a standard when it comes to freedom of expressions? Yes, we don't have the UK Act, but could we reach the same conclusion through the common law route, that when it comes to important rights like freedom of expressions, and in a lot of this kind of interim relief case, the interim relief is as good as the final one, because no one is really concerned about the final proceedings. So the court, by adopting the balance of convenience test, is just too low a standard and would not be given full effect to the constitutional right?
Well, I think that's a very interesting thought. It's certainly not the law in the United Kingdom, but what it does remind me of is that this is what just indicates merely my age, I think. But there was a time when the Labour government in the 1970s introduced a different test for trade union litigation, because as you may or may not know, in Britain, rather curiously, any industrial action is inherently unlawful because it's a breach of various economic torts. So it can only become lawful if you get within what was then the golden formula. Now they've set up so many different obstacles. It's entirely an accident if any piece of industrial action turns out to be lawful, because there's so many things to go through. But the point of that digression is that they actually introduced a different statutory test. But I mean, I do see the force of the point you make, which is that where you are dealing with what's essentially the decisive element of the case, then the American side test doesn't appear inapposite. And the reality is, you know, judges like to think that they're practical men and women. And it's not very difficult to spot a case where the interim relief is going to determine the whole case. And it seems to me, I mean, I think it's difficult and I haven't thought it through, but there is scope for saying, I would have thought, that if there's you can say with reasonable certainty that a case is going to come to an end, then it may not be proportionate to apply a balance of convenience test. I mean, that's an off-the-cuff thought, but it does seem to me that there's some force in that.
Thanks. I see a few hands, maybe Margaret and then Eric. Yeah.
The Court of Final Appeal had given judgment in the Kwok case, and you'd be interested to see that the government argued that from the point of view that the right is not engaged because it was on private property. And the court didn't accept that argument. So it may be interesting to see what you think about the court's line of reasoning. The case that Johannes was referring to, the children case, myself and Gladys Lee, who's here, were involved in that case. And And we didn't think that the balance of convenience was the right test. But in that particular case, by applying that test, you basically have no freedom of demonstration, because the court took the view that since the protesters were unlawfully on the public highway, that they have no right to speak of. So even if the other side had a very dubious right, that would trump the other side. So, and the interim injunction was a rather daunting one, which, as it played out, amount to clearing the occupation of the protesters. And it is difficult to see, without relating the AG, the Secretary for Justice, how you're going to grant an interim injunction to a private party to clear the site of hundreds of occupiers. And so I think that at some point we have to revisit the test to see in this kind of situation whether the balance of convenience is the right test at all.
Well, I see that. I mean, it has to be said that actually, in the hierarchy of rights, freedom to assemble tends to not be particularly given a high status. And that, I think, perhaps reflects that, at least in the British law, the fact that trade unions were unlawful and all that, because the common law in that field is not strikingly progressive. But I think it is genuinely quite difficult. And I would have thought if you wanted to open that issue up, it's a very good example, I think, of where if one's trying to run test cases, you have to choose a case with really quite good facts. Because it's going to be much easier for a judge to say no than yes. So the worse the case on its facts, the harder it will be. But I suppose one could envisage scenarios in which it would be easier to do.
Yes, Mr. Clayton, may I first thanks very much for your insightful speech. Just 2 points to supplement. On the Kwok case, the CFA delivered judgment early this month. I think you may find some comfort in the decision that basically the CFA, our final appeal, ruled along the line that you suggested, because basically it rejected the government's argument that this constitutional right of freedom of expression could be trumped by property rights. And then the basic approach is to adopt the proportionality test in respect of whether the restriction can be justified. So that should be in line with what you suggested in other jurisprudence. Although eventually the appeal was still dismissed by the CFA, I think the main focus is on the justification that the Legislative Council's business should be orderly in a sense that not to disrupt the local business, because if you have people demonstrating in a public gallery while the local section is in session, then they may attract counter-arguments, and then you have this kind of chaotic situation. So I think the main focus is on that. The other supplement is that on the balance of convenience, I think we do have quite a few local cases which also rule to the effect that you mentioned, that if the interim injunction was basically, in reality, would dispose of the final outcome, then the court may need a higher assurance rather than the general arguable test. But the question I want to put to you or ask you is that I think nowadays the talk of the town is in respect of whether we have a right to advocate for Hong Kong independence, and also there will soon be legislation about the national song, that if people sort of do something which shows disrespect when national song is being broadcast, then that could be an offense. So do you have any views on that, whether that could be justified?
So,
There is a proposal, or at least it has been a law in China
now, which might be extended to Hong Kong, is that if one is not respectful when national anthem was played, it could be a criminal offense. Right, yeah. And the other thing is how far freedom of expression should go, and one of the issues in Hong Kong is, seems to be recently, there are a lot of criticism of people advocating independence and even suggestion that you cannot discuss independence of Hong Kong.
Yeah, well, dealing with the national anthem seems to be a bit of a popular subject at the moment, because Mr. Trump, President Trump, who is remarkable in many respects, seems to be taking on the whole of the world about his views on that issue. But I would have thought that so far as I mean, it just seems to me that protesting in the national anthem is inherently a political act, and in a sense, if we do attach any weight to the notion that freedom of expression isn't just to be for things you like, but it's there to do with things you don't like, then it seems to me that, you know, that organizing a riot because the national anthem was being sung, that's obviously, you know, seriously criminal activity. But, for example, going down on a bended knee, as some people are doing in the United States, that strikes me as entirely, well, it's difficult to see that's outside the scope of a constitutional right. The point about, you know, the views that you hold is really very interesting, and it dovetails a bit with what the case I find simply extraordinary, which is the one about the by-election case. I mean, at the end of the day, political speech either is important or it isn't. And actually, I mean, you can produce just tons of cases saying that of all forms of political speech is the most important. So, I mean, I can perfectly understand that there'll be people who find expression of views unattractive or uncongenial, but that isn't, as far as I'm aware, the decisive factor. And really, it seems to me that any attempt to inhibit or define the scope of political views, which are political, and that's why the boundary between criminality and politics matters. It's also why the distinction between speech and conduct matters. I mean, those distinctions are there because they represent something important about the quality, character, and significance of expressing views which not everyone likes. And it really is as simple as that. So I'm afraid for my part, I don't see, it would be a radical curtailment, and it would be out of step with many other jurisdictions where that's a direction that Hong Kong went in.
Yes.
Hi, Mr. Clayton. Thank you so much for sharing your illuminating insights. I just want to draw our attention back to the Kwok King case. You mentioned that you were a little bit surprised by the lack of consideration that the Court of Final Appeal had to the case of Sauvé, the Attorney General of Canada, and you emphasized that in that case the courts had mentioned that the importance of, like, the central role of constitutional rights in the exercise of elections.
Yeah.
I have one comment before wanting to ask for your views on this. One thing that does sort of, I guess, bug me is the fact that there seems to be an issue of in terms of bringing in comparative jurisprudence, is that it would be relying on an underlying premise that, like, Hong Kong is a democracy in the first place. And so it seems to me that there is an issue with trying to be able to draw on the strengths of constitutional rights protections in other countries, given the fact that their sort of political circumstances are different from ours. So the question that I want to ask you is, to what extent, do you think, or if you have any thoughts on how the courts could go about developing approach to drawing on the strength of constitutional rights protections in other jurisdictions, with taking into account the fact that we aren't actually, unfortunately, yet a democracy?
Well, I mean, can I give a slightly long answer to that? I mean, you see, this is an example of how comparative law can be quite significant. The Sauvé cases are actually really, really interesting because the approach taken by the Supreme Court of Canada to those cases is really very striking, because I don't think that people are particularly aware that the Canadian Supreme Court looked at the issue twice. It looked at the issue, it struck it down, and then it came back. So the government changed the proposal. Some while ago since I read it, so I can't remember what the change was. And the issue that crystallized between the majority and minority judgment was, well, it's the legislature, they've had another go, that's the last word. And actually, the Canadian Supreme Court said, no, it's not good enough. And so that's just an interesting example of a really powerful case. So I did find the way it was described by the Final Court of Appeal is surprising. That said, it's important to take a nuanced view of to what extent comparative law can inform constitutional issues. But I think some things are relatively straightforward to say. I mean, for example, if there's a consensus, as there is on some issues, that's one thing. I mean, the thing that struck me as remarkable about the constitutional case, the Court of Final Appeals case, is there was no case that was put before the court which was remotely close to the one that they were considering. And therefore, to retreat into general statements of deference, I find, strikes me as open to question. As to the specific point you make, well, obviously it's important to be sensitive to cultures and the stages of a society that you're in, and I perfectly understand the point you make specifically in the political context here. But an argument which cuts the other way is you might say that a culture which is developing a political democracy is one where it's more important to maintain ground rules. Because assuming, a difficult argument to advance, I should have thought, is an argument to the effect of, well, we're involved in the process, but we don't want to end up in a democracy in Hong Kong. I would have thought anyone would find that a difficult proposition to argue. So if you take that as a premise, that there's a consensus around that perspective, then it seems to me the argument that, well, we're not really there and therefore we should step back is actually rather unconvincing. Now, I say all these things without having had the benefit of thinking them through very deeply, but it doesn't strike me as a particularly strong, because you get one thing that one has to be alert to is a kind of infinite regress kind of argument where basically you're bottoming downwards the whole time because you're saying, well, we haven't got there yet, so we've got to cut our cloth accordingly. But that actually never ends, you never end up closer to where you're trying to go. You're getting further and further away. And that strikes me as a difficult argument. I mean, and I suppose I should also say that, some of the things I'm saying, their arguments should strike me as having force. Whether they'd win, depends on a whole set of factors. And of course, judges, like everyone else, are alert to the general environment in which they live and the sort of social pressures, etc., that we all have to labor under. I hope that's helpful to an extent.
Right, in the interest of time, I think I will take the last questions. I saw Martin has put in the hands up. Yeah.
Mr. Clayton, I'm very glad you came and delivered this lecture. I think on the whole, whenever the Court of Final Appeal, when you said they got it right, I was counsel in the case in some of them. When you said a little odd, I was also counsel in the case when they ruled against me. But there is a very difficult situation we find ourselves in because our legislative council is not truly democratically elected. And that is why a lot of cases were taken to the courts, even though they actually concern political decisions. And then when you find the court saying, well, this is really a political decision and we defer to the government, then that is a huge hardship to the people. And that is a great, great problem. And very often, in very difficult cases, they won't even give leave.
Right.
Now, and sometimes they actually ordered costs against the unsuccessful applicant for leave, even though it was ex parte application. The courts would very often now in Hong Kong invite the government to be present. And when the government won at the initial stage, which was supposed to be ex parte application, the unsuccessful applicant was condemned to pay the cost. So you see how difficult it is for these freedom fighters to go to court.
Well, I do entirely understand that. I mean, you know, the reality is that that often good cases lose. You need to have good facts, probably. You need to have a good argument, and you need to have a sympathetic judge. And obviously, well, I mean, just taking it from I'll deal with it in the context of the United Kingdom. The Human Rights Act has really run its course, I think. I mean, one of the great privileges of writing the very, very, very long book was that Lord Bingham was hugely enthusiastic about it, and he wrote the prefaces, and he used to buttonhole, you know, myself and my co-author and talk about it. And, you know, he was an extraordinary man and a great privilege knowing him at all. And they've lost interest in it now. I mean, they're bored with it. They've done their bit, the judges. So it's a new generation. And of course, the judges are also, you know, come from a different period. Many of the people who are coming through the system now were born, you know, were kids during the Thatcher years and so forth. So they just have a completely different political perspective. And there's not much you can do about any of those issues, except, I suppose, you know, try and express it as attractively as one can, arguments which need to be made. But it does, I mean, the point which I hadn't thought through, which your colleague made just before you, which is a really interesting one about, you know, the fact that you're halfway, or perhaps not even halfway, or whatever you want to call it, you're on a road and you haven't got to the end. I mean, that doesn't seem to me logically, or indeed as a matter of principle, to justify an argument that you just get stuck. I mean, why should that be? Assuming that the government isn't going to come out and actually say, well, we're against all of this. But I do appreciate it's a long-running and difficult issue in Hong Kong, and no doubt will continue to remain so for the foreseeable future. So I'm sorry, a bit of a vague answer for which I apologize.
Right. Thank you, Richard, for this very insightful lectures, and I'm sure everyone here is impressed with the range of issues that you have covered, and particular for someone just coming from outside who showed that breadth, range of knowledge of Hong Kong cases. And if your appetite is not satisfied, Richard is going to give 2 more lectures this week, so do come and join us tomorrow and on Thursday. So let's give our traditional way of thanking Richard for these lectures, and thanks everyone for coming.
Thank you.